Thank you very much, Gary, for a very interesting presentation. Obviously, it is highly important that the Assembly members understand the historic position in relation to referendums in this jurisdiction. And Gary has given us an awful lot of information, and it's very, very useful. And I'll probably be repeating this all day, but you have a very good paper. I'm talking to the members now. You have a very good paper from Gary, and I would recommend that maybe you revisit it if you have time today. We're now going to hear more about referendums. This time we're going to hear about the legal background and how the process operates, and we have Niamh Hyland, Senior Counsel, to talk to us on this topic.
Good morning, everybody. I'm conscious that you all know Miss Justice Lafoy as the chairperson of the Assembly, but I remember her very well as a judge, so I'm determined not to go over my time limit. And since we've been told that this is the most punctual gathering in, I think, the world, I will move on immediately. I don't have PowerPoint slides, but I do have a paper which I think you all have, and at the back of that paper there is the text of the Constitution, the relevant provisions that I'm going to look at. And I do have a short time. I know you all have a lot to get through today, so I'll be skipping along quite quickly over a couple of different topics in respect of the law relating to referendums. And I'm going to call them referendums. I know that the Referendum Commission says that they get complaints every time a referendum is held about them not being described as referenda, but it justifies its decision and says that you can call them both referenda and referendums. So I will use the more commonly known term. So you've already heard a bit about the history of referendums. There was in the Free State Constitution of Ireland in 1922, Ireland's first constitution, a referendum procedure, and in fact that had what was called an initiative mechanism. It meant that the people alone could trigger the holding of a referendum. Now it has to be done by way of a decision of the Oireachtas, but at that stage, if there was a petition of 50,000 voters, a referendum could be called. That was changed in 1937, but nonetheless the possibility for a referendum remained in place. And it was considered to be a substantial change from British parliamentary democracy, whereby only the Parliament dictated what was, I suppose, the relevant provisions governing the people. And because it is relatively easy to have a referenda in Ireland, as you've heard, there have been a very considerable number. And essentially, what Article 46 of the Constitution says is that proposals to amend the Constitution shall be commenced in Dáil Éireann by way of a bill. And if the bill is passed, then a referendum will be held. And a bill to amend the Constitution mustn't contain any other matters. And if the proposal is approved then by the people following the referendum, the bill is signed into law by the President. So that is the mechanics of what happens. And whenever the Dáil decides to bring forward a bill, the text of what is going to be put into the Constitution, if the referendum is passed, will be in a schedule to the back of the bill. So that's where you find the text. And obviously, as you're aware, there will be much political debate before that text is agreed. But once it's agreed, that's the text that is put to the people. Now, once the proposal is put to the people, what happens then? Well, under Article 47 of the Constitution, it must be approved by a majority of the votes cast in favour of the proposal. And it's just a simple majority. There's no percentages or minimum amount or number of constituencies or anything like that. It's a simple majority. Who can vote at a referendum? Well, anybody who has the right to vote at an election for members of Dáil Éireann can equally vote at a referendum. And generally, that is an Irish citizen, age at least 18, whose name is on the register of voters. So there's nothing different about the people who can vote at a referendum. And Article 47 also says that legislation can be adopted regulating the holding of a referendum. Because one of the things that is great, I think, about the Irish Constitution is that, unlike the Treaty on the Functioning of the European Union, our Constitution is still a nice short document, and you saw the previous speaker holding up a copy of the Constitution. It has general principles set out in relatively simple terms, and then the detail is regulated elsewhere. And that's what we have for referendum, because Article 46 and 47 between them probably don't take up much more than a page. But then you have the Referendum Acts, in which there is considerable detail about how you hold a referendum lawfully. And as I say, the simple majority means that sometimes referendum are passed by very small percentages indeed. For instance, the divorce referendum of 1995, the difference between the two sides was only 0.58% of the vote. So that is a tiny amount. Now, what about those acts that I mentioned which regulate the holding of a referendum? What are the important things they say? Well, one of the things is timing, and this probably impacts on what you're going to hear later about the media and the Referendum Commission and so on. Once the bill containing the proposal to amend the referendum has been passed by the government, there has to be a polling day between 30 and 90 days from the date of the making of the order. So that's not very long. In other words, it must be not less than a month, but after that, it has to be held within 90 days. And the constituencies are the same as they would be for Dáil elections. And in relation to how you mark your vote, it's more or less the same. You mark it as an X. There's a provision for recounting of the votes. And what happens once a referendum has been held, there is a report from the local returning officers, and the referendum returning officer then signs a provisional referendum certificate which records the numbers of votes for and against. And before I come to challenges to referenda results, which I'll deal with shortly, I just want to mention the Referendum Commission. I think you are going to have other speakers dealing with that in more detail, but just in summary, the reason it was set up was that there could be neutral information given about referendum proposals by the state. And that followed a judgment called McKenna, where Patricia McKenna, an MEP, had challenged the fact that the government was funding campaigns which were directing or advocating a particular result, and that was held to be unconstitutional, and therefore it was decided that in future there should be a neutral body, the Referendum Commission, which would advise the people. And the functions of the referendum have changed a little bit over time. They used to have a function of of setting out the yes and no arguments. And some of you may remember those quite bewildering TV ads where you would have people identifying the for and against arguments in very complex and technical matters, which was sometimes difficult to understand, I think. In any case, in 2001, that was abolished, and now the Referendum Commission just have three discrete functions. They have to explain the subject matter of the proposal and the text in the bill, and you'll remember that I said in the bills there's a schedule which sets out the text as to how the Constitution will be amended if the referendum is passed. So one of the jobs of the Commission is to explain that text. They must publish and distribute their explanations in a variety of different media channels. And then they must also promote public awareness of the referendum and encourage people to vote. And who's on the Referendum Commission? There's a judge, Controller Auditor General, the Ombudsman, the Clerk of Dáil Éireann, and the Clerk of Seanad Éireann. Now, can I just, conscious as I am of time, can I just move on to challenges to referenda? And you will probably be aware that there have been a number of challenges taken in the courts, and the way those challenges work is that after the votes have been counted, but before the act has been signed into law by the President, there's, if you like, a short window within which a challenge can be taken. And I suppose challenges can be divided into challenges before the referendum is taken and those after the referendum is taken. And the before type challenges that I want to briefly look at are those which consider the material presented by the government. I've mentioned the McKenna case, where it was held that the government couldn't fund material advocating a particular result. More recently, that was tested in a case called McChrystal. And you may remember in 2012 there was a children's referendum. And just 2 days before the vote was to be taken, a challenge had been brought by a person who said that the government material was not neutral, and the Supreme Court decided that Mr McChrystal was correct in that, and that the 1.1 million that had been spent by the government on that material had been, or at least part of the material had been directed towards a particular result, and therefore was unlawful. And the Supreme Court didn't in fact grant an injunction, because they said, well, we know the government will take whatever steps are necessary in relation to the withdrawing of the material, and the government did do that. But at that stage there was just 2 days to go before the vote was to be taken. So the vote went ahead, the referendum went ahead in relation to the children's referendum, and the outcome was 58% in favour of the referendum and 42% against the referendum. And a challenge was brought by Miss Joanna Jordan, who sought to set aside the outcome of the result on the basis that material had been in circulation for a number of weeks which had been unlawful, which had been seeking to persuade voters implicitly of a particular result, and that therefore the outcome should not stand, and the referendum result should be set aside. And the Supreme Court had in fact already dealt with this issue before in a case called Hannafin. You remember I said that there was a tiny majority in relation to the divorce referendum, and that divorce referendum had been affected by the McKenna judgment, where there had been a government campaign that was ultimately found to be seeking to direct a particular result. So Mr Hannafin sought to set aside the result in the Hannafin case. And he was unsuccessful. So, in a sense, the Jordan case was revisiting the same territory. Now, what is the legal test if an applicant is seeking to set aside a decision? Well, Section 43 of the 1994 Referendum Act sets it out clearly enough. It says a referendum petition can question a certificate if the result of the referendum as a whole was affected materially by, and then there's a number of things that can affect it, the commission of an offence, they are electoral type offences, obstruction or interference with other hindrance to the conduct of the referendum, failure to complete or otherwise conduct the referendum in accordance with the Act, or mistake or other irregularity in the conduct of the referendum or in the particular stated. And then there's a caveat in the Act. It says that a referendum petition must be dismissed if the informality doesn't materially affect the substance. So I suppose when you look at the decision of the Supreme Court and when you look at the Act, the net effect of it is that there must be a material impact upon the result of the referendum. It must be affected materially. And there is an important discussion, I think, in the case of Jordan by the Supreme Court as to what that actually means. And the Chief Justice held that it means that it substantially altered or changed the outcome of the referendum. There's a very interesting decision by Mr Justice O'Donnell, and what he says the test is that material effect means establishing that it is reasonably possible that the irregularity or interference identified affected the result. So it's all about cause and effect. Has the thing that's gone wrong materially affected the result? And he goes on to say, because of the flexibility of that test, and you can tell already from the words I've used that the term material affected the result is not a scientific term, it has to be interpreted in every case. But what he said was that the object of the test is to identify the point at which it can be said that a reasonable person would be in doubt about and no longer trust the provisional outcome of the election or referendum. And I'll finish on that note. There's lots more good stuff in the judgment of Mr Justice O'Donnell, but I think the word trust is very important. What he's essentially saying is that if something has gone wrong before the referendum, in this case the provision of information by the government that was partisan and shouldn't have been, and if the people go to the polls and they vote in favour of the referendum, and if there's an application to set it aside because of this unlawful information circling around, and in any other circumstances where there's a complaint about what happened, when the courts are faced with the incredibly difficult decision as to whether or not to set aside the decision of the people, which is, of course, a huge ask, what must they look for? They must look and see whether or not, if they didn't set it aside, would there be such a doubt about the result that the people would no longer trust the outcome of the referendum. And that is the test that a court will look at when deciding whether or not to set aside a referendum. Now, I could talk to you for another hour easily on all of this, but I know time is short, so I will leave it at that. And thank you for your attention.
Thank you very much, Niamh, for giving a very good overview of the law as it is now. You'll have learned that you're going to have to consider the constitutional provisions, statutory provisions, and also the decisions of the superior courts. And you have a very, very good paper from Niamh in which you get a fuller picture. And I strongly recommend that every member reads that paper, because we're going to be coming back to these issues throughout the day, and again tomorrow. We're going to be talking about the McKenna principles. We're going to be talking about referendum commissions and so forth. So I think it would be in everybody's interest to read that paper at some time today if you get an opportunity, because you will get. You've got a broad picture now. You'll get more detail, and it's very, very helpful. So that really is the end of this public session, and the members are going to get an opportunity to discuss what they've heard and determine what questions they may want to ask later. So we're going to resume the public session at 11:05. Very good. So we'll move on now to the private session.